We're
Well,
about out of time, just in case anybody has any
yeah,
last
my
question. But go
reflection
ahead.
is just a gratitude. Just from what I've just heard, and kind of like Ms. Polk just said, that someone just understanding. And yes, there are next steps. And I quickly just want to say that Ms. Schaefer, who's the head of parole board, who was on in the first panel, she mentioned, hope is providing a lot of people hope, and hope. And for me, I couldn't hope with a distorted reality, right? My reality was life sentence. My reality was prison. And so I had to be grounded in reality, because I was also fearful of hope. But what's important is tangible hope. I had to see it. I had to see the people. I had to see the law. Let me read the law that's been changed. I need to see that not just the outcomes, but recipients of hope tangibly. And so I just want to close off by saying offering my gratitude, one, to be on this panel and to present, and then hearing back some of the comments and powerful questions from the panel, the rest of the members. I'm just appreciative. And because of that, I'm hopeful.
Can I add one very short, quick thing?
Of course.
So it was something Anad said earlier, and I wanted to bring this up about the staff and sometimes how individuals are treated. And since I have paroled and been going back in, I have had 3 specific officers who apologized to me for the way they have behaved. And all 3 of them, women, had said, it's what they tell us. We have to have this wall. We have to have this barrier to protect ourselves. And maybe I'm thinking, maybe that shouldn't be so stressed in their training, because I would have never expected these particular officers to apologize. And I really felt their apology was genuine. And a lot of times it just makes the time that I did so much harder, being, antagonized and picked on and being told no for no reason. And it just adds to the more of everything else I'm already mentally going through. And now here comes this particular officer who wants to just make the day worse. So maybe in training initially, it doesn't have to be drilled into them. And I so get that it is to protect. We inmate officer, I get it. I don't think it has to be so harsh and drilled in at the end of the day. That was it.
Senator Skinner, you'll have the last word, or last question.
Well, I was just reflecting on everybody's comments, but Dean Richardson's and what both Adnan and Shanae experienced. And it kind of goes back to when we were discussing parole. It's like the very environment we've created with our prison system is in a traumatic environment. And what Shanae just described is that then the correctional officers are trained to, in effect, enhance that trauma. And yet then we expect people to have whatever insight or whatever words. And so we're doing penal code review. So we're trying to look at the penal code and how we fix it. But I think and yes, we must do that. We have to take our charge seriously. But I think we also have to look at just the structure of the environment that we created, that it alone does not contribute to public safety. It alone, the dehumanizing, not only for the staff, but also for the individuals, it alone is contributing to a lack of public safety. And the irony is that it's very expensive. Additionally, we spend an enormous amount of money on each person each year that we hold them. It's very, very expensive. It's more expensive than anything else we do almost in this state. So, I think that when we think about our changes to the penal code, we can also think about, all right, what potential savings might that create by virtue of holding less people, by sentences fixing and such, that could then potentially be translated into the kind of services that might then address the experiences, say like Shanae's experience. Had she gotten trauma counseling as a kid, had she, got just the whole circumstance that she experienced, which she described, led to her situation. So anyway, this is a dream I think many of us have. We certainly, when we look at organizations like Smart Justice, like Californians for Safety and Justice, a lot of their premise is that about trying to make adjustments to sentencing and to other things so that then we free up some resources to put those resources towards what the real problem we're trying to address. And again, that's a lot to take on for a Penal Code Review Commission, but I think we do have to factor those things in all as we evaluate what we pursued as recommendations, that we evaluate them from those perspectives.
I'm just going to wrap this session up to say thank you to Ms. Polk and Mr. Khan. I think one of the things that I've learned today or realized again is, Mr. Khan, these numbers that we make up about how long does somebody deserve, yet and I think the state, the good news is the state has been gradually moving back towards some sort of indeterminate scheme, right? As we talked about at the beginning, 55% of people who are in CDCR custody right now have a chance to get out earlier than their sentences would have other been. So go through, but it's a completely ad hoc process. It's created by Prop 57 and the PLATA 3-judge panel and the parole process that itself has 3 different standards. And I actually think that there's an opportunity for this committee at least to create coherence around that group and maybe push even further beyond the 55%, but to make it at least more rational and sensible, and also give more people opportunities, especially those who deserve it. You guys are inspiring to us. I'm pointing on my screen to Adnan and Sinead. So thank you so very much. Again, as I said to all of our panelists, we'll be in touch, but also very specific reforms can be the most helpful things for us. Ms. Polk, I can't believe that you have to do this on a volunteer basis. I mean, that's just absurd. But let me just say this.
Unconscionable.
But let's say thank you. How about that?
Thank you.
And I know, Adnan, I know that you do a lot of work too. I don't want to leave you out. And it should be said that he was he was the very first person, I believe, in the state to benefit from the change of the felony murder rule. Is that right?
First person resentenced. There was an individual who was in jail for 9 years fighting the case, but I was the first person resentenced.
Okay. Well, in any event, you guys are walking examples of how these different reforms are this ad hoc process is coming together to bring a little bit of justice, but it's far too little. And you guys are, show that. And I think that, as I said on day one, when we started this committee, that we can both reduce incarceration and improve public safety at the same time. And I think you guys are, I can't imagine better examples of doing that. So that's where we're headed on a global scale. Well, that's where I am, at least. All right. With that said, we are running a little bit behind schedule, and we're going to move to the public comment period. Thank you both. We'll be in touch. And so let me read some rules about the public comment period. There's a lot of people who are here. We really appreciate you staying with us throughout the day. So we've reached the time for public comment. To get in line for public comment, please use the raise hand function on Zoom. If you're calling in, you can hit *9. Please note that this meeting is being recorded and that if you make a public comment, your name and phone number may be displayed as part of the recording. If you'd like to comment, please raise your hand or dial *9 on your phone now, and we'll take a few minutes to see how many people line up. And based on that, we'll see how long people have to comment. While I'm waiting for people to line up, I want to acknowledge that there have been voluminous written comments that the committee has received in the past few days. Much of those comments have focused on life without parole and 3-strike sentences, issues that the committee is extremely interested in, but will not be considering this year, primarily because modifying them would require a 2/3 vote of the legislature or a new ballot measure. We deeply appreciate the written comment, including the hashtag that some people have been using, hashtag change the code. And we look forward to hearing more and working towards reforming those parts of the penal code as well. So that said, let me see how many folks are in line. Looks like about 20 people. I'll give a few more. 1, 2. All right. It does look like it's about 20 people or just under that. We're going to limit it to 2 minutes apiece, just so we can get through. Tom, are you able to manage the queue, or is that something that I should do?
I got it, Mike. We're good.
Ooh, I didn't hear that, Tom.
Yeah, I can take care of it, Mike. We have our first commenter, Karen McDaniel, ready to go.
All right. I couldn't quite hear you again, Tom, but Karen, I think you're ready to go.
I am. Are you able to hear me?
We are. Thank you for joining us.
Very well. My name is Karen McDaniel. I am the executive director of the Place for Grace, and we represent more than 200,000 children in the state of California that have an incarcerated parent. We run program at 17 CDCR prisons, and I am directly impacted by incarceration in that my ex-husband and the father of my 2 teenage children is approaching his 21st year incarcerated in a California prison. I think the fact that he was sentenced at 19 years old to 35 years for robbing McDonald's, in which no one was physically injured, really highlights some of the same issues that we've been talking about during these almost 4 hours that we've been on today. I've been here since the beginning. So yes, there are some really serious systemic issues that have been, reiterated by Adnan and Shanae this afternoon. But specifically, because this is a penal code revision committee, I want to specifically address some questions that repeatedly came up today. How can we get more people home? And who best can tell us who ought be coming home and who is prepared to come home and safe to come home? And I want to very specifically uplift program providers like myself that go in, most of whom are directly impacted, like Shanae, who just spoke. If we have any funding at all, it's very little. And we go and we do the work that puts the R in CDCR. We are the rehabilitative force for CDCR. And we, by and large, are formerly incarcerated and system impacted people. And, I think it was Heidi Rummel said earlier that, well, officers on the yard may know if someone's rehabilitated, or, lawyers have a good assessment, or perhaps parole board members. And I'm here to say that program people that go in week after week after week and work with our people inside and talk about things like childhood trauma, we are best equipped to tell you who can come off those yards. And we know hundreds of people that are ready to come off those yards. That means that the parole board has to be representative of people who are formerly incarcerated and who are system impacted. That means that we also have to be able to refer people for 1170D. Not just DAs. Thank you.
Thank you, Karen. Thank you, Karen. I really appreciate it. I think we all agree, and why we've made a big effort to have system impacted people as part of these hearings at the very least. So thank you very much. Crispy, I think you're next.
Yes, thank you. To ensure Penal Code 1170D1 resentencing referrals are carried out according to legislative intent and due process, I'm asking the committee to advocate for amendments to the law, including it should be amended to clarify a person's immediate right to notice and counsel when a resentencing referral by CDCR or a district attorney is initiated. It should be amended to clarify that the judge must calendar the referral letter in a short time frame. It should be amended to create a process and presumption in favor of enhancement time being removed when laws pass that repeal or make discretionary certain enhancements, regardless of whether those laws are retroactive. DAs, public defenders, and CDCR can work collaboratively or independently to create lists of people with enhancements by county and refer people back to court en masse to reduce overcrowding and accomplish what legislators intended PC 1170 D1 to accomplish, to address disparity in sentencing and release people when further incarceration is no longer in the interests of justice. People should not still be serving decades of enhancement time when those enhancements would not have been added to their sentence if the person was sentenced today. It should be amended to create a self-referral process by which people can formally refer themselves for review for the removal of enhancements that are either illegally calculated or disparate in application given recent changes in law. This self-referral process can be comparable to a petition for a writ of habeas corpus or the SB 1437 and Proposition 36 petition processes. Thank you so much for your time.
Crispy, you've read our minds in some ways. I encourage you and everybody else to attend the continuation of this hearing tomorrow. We'll be going over some of our proposals, many of which you touched on. So thank you for your comment. D. Caver, you're next. D. Caver, you're on mute.
Okay, I'm unmuted. Thank you.
There you go.
Well, I'd like to say I'm from the Inland Empire. We organize out here, and I do a lot of legal work. That's kind of where our focus has been recently. And I just want to bring up, when it comes to this committee, speaking about simplifying and rationalizing the substance of criminal law and criminal procedures, I encounter that stuff all the time where it's not rational, the system that we're dealing with. And in particular, I want to raise up some issues just regarding due process, illegal detentions, and what really alarms me is failure to appear with individuals who are in custody, not making their arraignment, even though they're in custody multiple times over. One thing I'd like to also bring up is I've seen that right now there's no bearing from our penal code when there's department policy violations from public employees. And I've actually sat through a court proceeding where a judge actually just straight told an attorney that it doesn't matter if this individual violated department policy, it has no bearing on state law. And that needs to be addressed because it just makes absolutely no sense. When a person commits a crime against a citizen, they withhold and they basically try to protect the individual that is employed by the state or the government institution. That really needs to be addressed in the California Penal Code because I've seen that come up multiple times. Also, I'd like to talk about a little bit about exculpatory evidence. In the counties that we organize in, San Bernardino County, Riverside, and even parts of Greater Los Angeles, we have tremendous issues with getting exculpatory evidence, and we have to contend with so many Brady violations. It's absolutely ridiculous. And I was looking through the California Penal Code on, how we could hold some prosecutors accountable for this misconduct, and it seems to be extremely lacking.
So Mr. Caver, I'm going to cut you off, not because what you're saying isn't interesting. For the most part this year, and the committee is a standing committee, we've decided to focus on sentencing issues. Of course, there are plenty of other issues, exculpatory evidence, misconduct, wrongful conviction issues that I think that we will also touch, further on down the road. I also want to reflect on something that you said about, I think that we all hope that although the changes that we might propose might seem technical, our hope is to really hit changes that can influence the culture of the criminal legal system more broadly. And we know that the culture and norms and the actual statutes don't always match up and they influence each other. And I think that we're well aware of that. And thank you for reminding us of that, I guess. Paul, I think you're next.
Yes, thank you. Thank you very much. First, I want to thank the committee and especially most recently Shauna and Adnan for the stories that they've told are very moving. My son is sitting in Twin Towers in Los Angeles right now, facing 23 years to life. He's been diagnosed with mental health issues. So we got a psychiatrist that did an evaluation. It was submitted to the court. We got actually the social worker in the court also recommended him for mental health treatment under AB 1810. And the judge said, he looks like a good candidate for this. We need to make sure he's in a secure facility. And that's where the road stopped. There are virtually no secure facilities, or very few, in Los Angeles County that meet the requirement of the court. So what I'm recommending is that if legislation is needed to shift funding or create some funding to make mental health treatment facilities secure enough to meet the requirements of the court, that would be a huge help, not only for my son, but studies have shown that upwards of half or more of all incarcerated people are in need of mental health treatment. Thank you.
Thank you very much for your comment. At almost every one of our meetings so far, the problem of mental illness in the justice system has come up in one way or another. I think some of the recommendations that we will be proposing this year might touch on that, but it's something that, this is news to the committee members themselves, but something that staff and I have been considering is really making mental health a priority for next year, like the way that we focused on sentencing this year. And it's an extraordinarily complicated and difficult question, not the least of which is the lack of resources and lack of treatment opportunities. So thank you very much for that, Paul. Joanne Scheer.
Hello, everybody. Thank you so much for your time. Thank you to Adnan and Shanae, and also to Sam for their stories today. They're so eloquent, and they speak the truth of what goes on in prison. I'm of course calling about those who are serving LWOP. I know that I've spoken with all of you before. I know also, Mr. Romano, that you will be talking about this next year. But I just wanted to reiterate that Jennifer Schaefer, when she was talking earlier, talked about the essential role that hope plays in the life of someone in prison. And what was also mentioned is that there's a current push to refrain from placing young people sentenced to life sentences directly into level 4 prisons, helping them to get the programming and education they need, and keeping them from the necessity of involvement in the violence of level 4 prisons. When the most common age that someone receives a life without parole sentence in California is 19 years of age. When a 19-year-old is given a death sentence, they're placed into a prison, immediately into a level 4 prison, whether they have mental issues, whether they have trauma in their background, whatever the case may be, it's not looked at. And as Adnan was so eloquent in saying, is that the points are added up and they are placed into level 4 prisons. And when you have life without parole, you are not given programming. I was told that the only way that my son could get an override to a level 2 is to go to an LTOP program. I did not know what an LTOP program means. LTOP is long-term offender program. LWOPs are not eligible to go to those programs. You must be parole eligible in order to attend that program. But I was told by the staff that he has to go to that program in order to go to a lower level facility. So that being said, I'm so looking forward to you addressing LWOP the beginning of next year. I so look forward to that. I also wanted to talk about
Scheer, I'm gonna have to cut you off because there are so many people behind you. I will say
Mike,
this.
can I just say one more? I'm sorry. Even though
quickly.
the parole board grants a parole, the governor has 150 days to deny, and he can deny that parole board even though the appointed board that he's appointed has granted parole. So that should be changed. So that's all I wanted to add.
We're well aware of that. And I do want to say about especially all the folks who've written to us and talk about LWOP. I think one of the lessons today, or one of the messages that I think you've seen, is that, you know, to try to build into the system an opportunity for redemption and a way out of prison and change. And obviously an LWOP sentence, you know, is completely contrary to that philosophy. I hope you see that.
Thank you.
Yolanda Navarrete.
Hello, thank you. I'm here because I wanted to let you know that my husband, his 53-year-old grandfather, who rehabilitated himself, and he's aged out of crime. He's been incarcerated for 26 and a half years on an LWOP sentence. I know you don't want to hear it, but I have to speak it. It's cost the state $2.2 million to house him in a concrete box. He has a home, he has insurance, and he has a job awaiting him. As loved ones of individuals serving life without the possibility of parole, we know these sentences are not in the interest of public safety. Studies confirm that the people released from LWOP or life sentences have the lowest recidivism rate. As a matter of fact, it's zero. Since 2017, 110 people have come home and not one of them has recidivized, has had anything done. We're constantly asked to wait, and we're seeking to address this issue. We need to take action now. Meanwhile, the population serving LWOP in the US has expanded by 400% since 1984. My last little paragraph. It's essential to the decision makers as are aware that the state will never be able to end mass incarceration without considering release of more people who are serving all types of sentences. We must end cruel sentencing practices like life without the possibility of parole and laws like 3 strikes if we truly are working towards real justice. Humbly, Yolanda Navarrete. Thank you.
Thank you, Ms. Navarrete. As I explained before, these are not issues that we don't care about. It's primarily because they require a voter initiative to be amended. And that next opportunity is 2022. So that's primarily why we're not focusing on it this year at least. But your point is, of course, well taken, as we've talked about. It looks like Paul Red, is that correct? The next person?
Can you hear me?
Barely.
Can you hear me?
Yes.
Can you hear me now?
A little bit better.
Okay, my name is Paul Red.
Hi, Paul.
Yeah, I have served over 46 years in prison. I was one of the first ones, I believe, that got out on 1170. I went to the parole board 14 times, was denied. My last board hearing was 2018, which I got a 3-year denial because I had a high risk assessment from 2016. Unfortunately, the regulation wasn't implemented during that time. That said if you had a high risk, you would not be advanced that 1 year. I was told by the parole board I was going to be advanced. But anyway, I listened to some of the comments. One of the comments that I heard that was profound was the parole board. Number one, the parole board used this discretion that they sit up here and decide when you go to a hearing what they're going to use. When they find you unsuitable, they use a lot of stuff when you was a juvenile. A juvenile at the time you never had a trial on, never went to a juvenile court on that stuff. And that stuff right there should be removed. I understand that the parole board can look at your juvenile factors, but if you never had a trial here and never was represented by a public defender or attorney back when you was a juvenile, that shouldn't be the basis of one of the criteria of finding you unsuitable. You know, the other little factor I wanted to use that the parole board, you know, they taking Title 15 that you are entitled to a fair and impartial hearing. Well, how can it be fair and impartial then when most of the people are former law enforcement district attorneys, wardens, even part of the SSU that sits on the board panel, who have also had dealings with you prior to that. There's never been a clear definition of what constitutes an impartial panel. That needs to be refined.
Paul, I'm gonna cut you off. It sounds like you've gone through quite a journey, but it sounds like you're out, and I am glad that despite 19 denials from the parole board that you've managed to earn your way out. You know, I don't know your whole story, but congratulations.
Yeah,
Next,
congratulations. I was put up for 1170 at Vacaville through the hospice program. All the workers got the same denial. We was rejected. Then all of a sudden, the public defender's office in San Francisco put me up for 1170, asking Chester Bodine to,
I know your case. I know your case. Congratulations, because it was a long fight. I would love to chat with you some more, but there's a ton of people behind you. But congratulations and good luck to you. We're going to go to Sutina Green now.
well, I hope we can finish. All right, thank you.
Thank you, Paul.
Actually, Mr. Romero, this is not Sutina Green. It's her husband, Stephen Green. I'm logged in on her account.
That's fine.
Okay. So I had the privilege today of listening to this very long call, but I listened through all three panels. I would like to first start off by saying I definitely agree with Mr. Watley's recommendations. I believe that he's spot on. I believe that Heidi Rummel's recommendations are also good. I believe that maybe more of the nuances of lawyers speak or people who understand the system very well. When we started getting into Lawrence and Butler and some of the cases that decided and opened up the parole board more for a relief mechanism to go on. 1170D, I think, is right now a waste of time. There's only 100, I believe you guys said 150 cases. I believe the reason that is because the judges, even though being conservative, do not know how to look at a person's C file. They don't understand what rehabilitation looks like, even after 20, 30 years. And so in essence, if they get that training and understand that this is not an attack on their sentence when they first gave it out 15 years ago, but this is about recognizing that human beings can change and that this person today in front of them, because of what they've done, should be given relief, right? Next thing I would say that the parole board, you can't compare our parole board to any other parole board. Most of the parole boards in the other states are dismal. So to say that, hey, we've got a great parole board because look at these other ones. If we're the leading edge in California of having a parole board, how do we judge success? The way that I judge success, especially when we give 13-something billion to CDCR, is that there should be responsible. They should be held accountable for preparing the people who go in front of that board. And at a dismal rate of like 30%, I think Keith Wadley said 20, but somewhere in there, either way, they're definitely not being prepared. So we give them. I'm
gonna cut you off again because it's such a long line. We couldn't agree with you.
That's fine. That's fine, Mike. No, that's fine, Mike. Thank you.
Okay, we couldn't agree with you more that the point of having parole should be to prepare and rehabilitate people and to have the different parts of the system working against each other and to have people like Ms. Polk volunteer their services to prepare people for the board is really something that's quite disappointing. I think it was evident. Disappointing is probably putting it too mildly. Trina Johnson.
Hello, thank you for hearing me. I would like to suggest that we.
Oh, Trina, you muted yourself.
Can you hear me now?
Yes.
Great. My husband is a lifer. He was sentenced as a juvenile. I also worked in the prisons as a LTOP facilitator. I taught the classes. I worked in rehabilitation as well. And I've been in prison myself, so I have a pretty good idea of the whole system in general. Basically, right now, I think that one of the things that would be most beneficial is eliminating life sentences for juveniles. Kids do terrible things, but they don't need to become worse people through life sentences. They need to be given hope, education, rehabilitation, and opportunities to be better people. Anything past 15 years is just extreme, honestly. After seeing everything that I've seen, I'll tell you that is within 15 years of being incarcerated, a person is either going to become better or become worse. 15 years is long enough for someone to decide who they're going to be and make decisions in that direction. Anything beyond that is just excessive. I also think for immediate releases or lowering the population right now, having everybody with a low CRA called back to board in about 6 months. I know it takes 6 months to process it, but getting those low CRAs to board sooner can help get their population down, get people out that are going to stay out and that have a place to go home to, that have earned that right and have earned their place there. Those CRAs do matter. They do carry weight. It's an official thing. So those are most of my ideas for now.
Well, thank you, Ms. Johnson. We really appreciate, your thought and all your work in prison. And of course, we wish your husband the best of luck and to work hard to earn his way out. It's a system that I guess we're all trying to make better. I don't know much else to say. Robin Rainwater.
Good evening. First, I wanted to really say thanks for taking on mental health upcoming. I think that's probably my biggest #1 issue. My name is Robin Rainwater. I'm calling from Yolo County. So one of the smaller counties that I think is being represented on here. And I wanted to talk about some specific issues that are related to minor offenses and lower level offenses. Proposition 20 sought to undo the gains that activists and reformers have made in the last few years, but the policies have been effective in decreasing the population of incarcerated people as it should have been. However, it has come at the cost of property damage and owners in communities many times, and has created some struggles that have been especially visible here in Yolo County and which caused Proposition 20 issues within our county. Our struggles are about increasing issues with no consequences for people who are repeatedly breaking minor laws. Without having penalties or consequences, the same people become habitual offenders for low-level crimes like increasing drug usage, stolen bicycles, problems with vandalism and property damage for the purposes of theft, business ownership problems, and these have all increased dramatically in my community. Blanket policies do not address this appropriately, and that is why I did not support the rescission of the victories in the past. One person can repeatedly be within law enforcement contact several times, sometimes even several times within a day when they are facing zero consequences as they are currently. Rational policy development should include increasing penalties for persons who are not complying with the laws of property and belongings. These are the laws that are causing communities to struggle. Many times these low-level offenders are growing numbers of people falling into the category when they continue to remain unchecked and undisciplined. I'm against
Robin, I'm just going to cut you off again because we have a long line. I have a couple of things I just want to reflect upon. We really do appreciate that mental illness is a huge problem with the justice system that we are going to need to think about, and it's not going to be an easy one. And reiterate what I said at the top of this, and actually at our very first meeting, which is our goal is not merely to reduce incarceration. It is also to improve public safety. And I think we can do that at the same time. I sincerely believe that is our goal. So your point is well taken on that score. Natasha Huey, I don't know if I pronounced your name right.
Yes, can you hear me?
I can.
Okay, great. Yes, my name is Natasha Huey. I'm a member of Surge Bay Area's Policy Committee, and Surge is also a member organization of CURB, Californians United for a Responsible Budget. And in the spirit of giving specific change recommendations, we need to change the code to retroactively repeal all sentencing enhancements. They are racist tools impacting Black, Brown, Native, Indigenous, and poor people of color disproportionately, tearing communities apart. California has a complicated scheme of sentencing enhancements that has led to exorbitant sentences and intimidated thousands of Californians into taking plea deals. Over the past decades, both the legislature and voters have created over 100 enhancements. 79.9% of incarcerated people in institutions operated by CDCR have some kind of sentence enhancement. 25.5% had 3 or more. By repealing sentencing enhancements for people who already serve time for their conviction, California can divest from expensive and ineffective policies of mass incarceration in order to invest in our communities. A specific example is we call for retroactive repeal of all gang enhancements, Penal Code 186.22, as they are racist in origin and in application, contributing to extreme and disparate sentencing, and are prevalently used throughout the state by district attorneys to target Black and brown youth and keep them incarcerated for decades longer than their peers, serving time for similar cases. Likewise, we call for a retroactive repeal of all nickel prior enhancements, gun enhancements, and enhancements for prior felonies. Thank you for listening and making this time to hear public comment.
Thank you, Natasha. As you may know, our last hearing last month was specifically targeted towards sentence enhancements. Unfortunately, several of the most common, including 3 strikes and gang enhancements, were added by voter initiative and can really be only amended or repealed by another voter initiative. But I hope you tune in tomorrow to hear some of our ideas that address some of the concerns that you raised, because definitely sentence enhancements are on our radar. Renee?
Hi, can you guys hear me?
Yes, we can.
Yeah, my name is Renee Segovia, and I want to thank all of you for having this committee first off. My husband is currently incarcerated. He was a juvenile offender that was sentenced to, he took a plea deal for 20 years with 2 strikes. And he's up for release next year. And the problem that we're seeing right now is because of his risk assessments, similar to Adnan. He's very high risk, and they're using, even though he's a nonviolent offender under California, they're using their discretion as it being a serious felony to be able to deny any sort of releases. So he won't qualify for COVID kickouts, nor will he qualify for a Prop 57 review that he's supposed to get in April. Another thing was that I filed an 1170D through our district attorney in San Joaquin County, and she's supposed to be relatively progressive. However, I don't know if I made enemies with her. She denied it. So I maybe I did it wrong, or I don't know. But for a juvenile offender that has a home, a job, circumstances are totally different. I'm not understanding why he's still being forced to send an entire serve this sentence that, because it's determinate. You know, they're not wanting to budge from that. And so hopefully you guys can change something with the serious felony issue and being able to take away the determinant factors of a release date.
Thank you, Renee. You know, the theme of today, I think, was to try to find ways to make indeterminate sentencing fairer and more effective. So thank you for your comment. Sharon Stewart. Ms. Stewart? You're on mute. Ms. Stewart, if you can hear us, I think you're on mute.
Okay, can you hear me now?
We can.
Oh, I'm sorry. Thank you for taking my call. I'm just wondering whether there will be resources needed attached to the recommendations that the commission may come out with. If there is, if you want those recommendations to really be implemented, I can imagine that it would cost some money. You have to get some money from somewhere. I want to suggest that Assembly Bill 1810, which has to do with mentally ill being in prison, if some of that money can be used associated with some of the recommendations that the commission comes out with. That's one question, right? Also, when you talk about stakeholders, that you want to hear from all of the stakeholders and get their input and all of that. Are you guys talking to, the family councils that are at these prisons where you, the relatives of the loved ones meet with the prison staff? You guys know about that, right? At any rate, I'm suggesting that these are stakeholders that should be contacted for their input, because they know what's going on, and these are the parents or wives of people who are incarcerated. Also, when you're gathering your data, would it be helpful to talk about the disproportionate impact on communities of color, on age groups? In other words, if part of this effort is to, yes, it's about public safety, and that's why we need to have these community facilities built so that the mentally ill don't have to be in prison in the first place, but data that might help for the legislature and for us consumers to look at things from a different point of view, that it's not just, public safety, yes, but how do you get public safety? Really, how do you get it? You don't get it by just locking people up. It's proven, we can see it. So let's look at some best practices where you're not having to lock people up because you are using strategies that are more community-based. Thank you.
Ms. Stewart, yeah, sorry to interrupt. I think we couldn't agree more, and that public safety is a bare minimum, and that success of people who are released from prison, for example, recidivism rate shouldn't be the only metric that people are measuring in terms of, whether you've successfully left prison. Also, mental illness is obviously a priority. And then finally, our very first witness, the person who convened this committee in the first place, was Governor Newsom. And, right out of his mouth was, that addressing the racial disparities in the California's legal system is a top priority for us. So, we're taking his lead on that. And I hope that you appreciate all these hearings, that we're really working hard to try to isolate the areas that we can have the biggest impact in a realistic way. Also, I should say that Senator Scheer is our budget expert, so I will defer to her for a sec.
Well, I thought the suggestion around the family councils was intriguing. I'm not sure where it fits in our agenda. In a funny way, in each of these discussions, there's some kind of an overlap with just conditions in the prisons, but that's not per se our charge, though. However, if part of our charge is public safety, we know that that making revisions to the penal code in order to reflect public safety and whether there's appropriate programming and such in the prisons, in other words, there's an overlap. And so we might consider whether we'd want to get some input from a couple of the family councils at some point in our process. I just wanted to give that acknowledgement to Ms. Stewart's recommendation.
Yeah, I forgot to say that. I agree completely. We work very hard to try to get a wide net here. Also, there's so many different areas of the legal system for us to attack. We've really focused on sentencing for this year, mostly as a place to start and for us to get an overview. But conditions are obviously part and parcel, and rehabilitation and parole. It goes exactly what we're talking about today. So I agree with that. EJ?
Hey, good evening, everybody. Thank you again. My name is EJ with Urban Peace Movement out of Alameda County. I do have a lot of family in LA County though. And just first want to thank you all for this important panel discussion today, which are especially, these issues in particular important to me because my brother was sentenced at the end of 2019 before SB 136 went into effect. He was given multiple one-year enhancements for prison priors after already sitting through 2+ years in the hellish LA County jail system. He was sent to state prison simply to serve these enhancements. The remaining time was unnecessary and excessive. It might be safe to assume that there are possibly hundreds of people in California prisons who deserve to be released today now that SB 136 and other laws are in effect, if we were to look at how much time they actually have remaining. So I'd like to voice my support for 4 of the changes that were mentioned earlier to PC 1170D1. The first was to clarify a person's immediate right to notice and counsel when resentencing referrals by CDCR or a DA is initiated. The second was the amendment to clarify that a judge must calendar the referral letter in a short time frame, so people aren't sitting for an additional 1.5 to 2 years before they even get heard. But the third and the fourth were most important to me, which would be creating that process and presumption in favor of enhancement time being removed when laws pass that repeal or make discretionary certain enhancements, which my brother would have benefited for and also benefited from. And finally, the fourth, which was the amendment to create a self-referral process so people can refer themselves for review. Thank you.
Oh, sorry about that. EJ? Apologies. Okay. You read our mind. You also read our. Very, very sorry. That dog was trained in prison, supposedly. So, and anyway, EJ, I think you also read our mind in that we agree that I agree, or one of the proposals that we're considering is what to do with enhancements that have been repealed prospectively. Very quickly, as long as you're on the line, how many one-year enhancements does your brother have?
He got 3, and it was
3 on top of his under.
Yeah, it was a 6-year total sentence.
So according to CDCR, there are 10,000 people who are serving this one-year enhancement. And I think that there is an obvious equity issue if you don't get it today. If you don't get it today, why should you have gotten it yesterday? So thank you very much. Colby Lenz, I think you're next.
Can you hear me?
Yes.
Okay. Hi, I'm Colby. I'm a volunteer advocate with the California Coalition for Women Prisoners and Survived and Punished and the Transgender Advocacy Group. We'll be sending more concrete recommendations in writing, but I wanted to mention a few things after in today. Yeah, thank you all so much for your time and your commitments to this project. In terms of parole, the parole board's so-called elder parole program needs to be overhauled. It sounds okay in name, but in practice, the elder parole grant rate is even lower than the overall parole grant rate, which is, as we heard today, runs around 20%, which is abysmal. The board's grant rate for people labeled with mental health issues is also horrible. I know this anecdotally, and I encourage the committee to request data from BPH if you haven't already on this issue. I recommend an overhaul of the parole assessment process for people with serious mental health issues. And as one example, the biggest mental health unit in the women's prison, CIW, nobody has been granted parole there in decades because of their mental health classification and where they are housed, and all of the bias that goes into that. That's despite, prison records and programming and all of that. The parole board's grant rate for transgender and gender non-binary people, especially trans and GNC people of color, has also been abysmal. This is another example of how explicit and implicit bias impact their subjective assessments of people. And this is also true for people who maintain their innocence. The board should not be allowed to deny people based on this, including through contorting the problematic concept of insight to meet their needs to deny people despite actual risk assessments and programming and all that. I also agree with the recommendation earlier that the governor should not have parole grant reversal power. California is one of very few states with this additional level of review, and it's a setup for senseless political decisions, in my opinion. And then I think we need an overhaul of sentencing laws that disproportionately target survivors of domestic and sexual violence, including murder laws generally, aiding and abetting and other accomplice laws, failure to protect and child endangerment laws, and felonies, murder, special circumstance laws that mandate life without parole. And then in terms of resentencing, I just want to reiterate that we need a self-referral process. The process that relies on CDCR staff recommendations will never be equitable. And I think the kind of culture of staff treatment and the way they're trained around so-called overfamiliarity are clear indications of that. And also recommend clarifying that people sentenced to life without parole be included in 1170D resentencing possibilities. Last thing is, of course, Shanae painfully described the lack of domestic violence programming at CIW. This is true across the prisons. This is for the women's prisons, despite the fact that the California State Auditor recommended more domestic violence programming in the women's prisons in response to the incredibly high suicide and suicide attempt rates in the women's prisons. So that factor, the connection between domestic violence and suicidality, has been laid out by the Centers for Disease Control and so on. And despite this, right, we're seeing Shanae going in as a volunteer to run the one program that exists at CIW. And
Colby, I hate to cut, go ahead.
Okay, very
Quickly,
last
piece. No, you have great, I let you go long because you have great thoughts, but so keep on going.
Sorry, Mike. Last thing is I encourage the committee to consider domestic violence diversion programs at the front end and at the back end. This could happen via resentencing laws, reforming Penal Code 1473.5, California's post-conviction DV appeal law, which has largely been ineffective, and we will send more detailed recommendations. Thank you.
Well, first of all, that was a great comment. You had a lot, there's a lot packed in there. I really do look forward to hearing your concrete recommendations. The only thing that I'm going to say that I reflect on is that I regret that we didn't get to medical parole or elderly parole when we had Jennifer Schaefer here. That conversation, as if you were part of it, was already going long, but those are two areas that I think that we also want to focus on. But thank you for your great comment. Marion Wickerd.
Hi there. First, I would like to say it totally broke my heart to hear the gentleman say that he's shooting down 1170D1. It needs improvement, but it doesn't need to be shot down. Without the possibility of 1170D1s and elderly parole, my husband Tommy's only opportunity to come home would be in 2050. That's 50. He has a determinate sentence of 57 years, 22 years for voluntary manslaughter. The other 37 years are enhancements. He's 19 years disciplinary free. As for witnesses for parole hearings, I totally agree with that. As Sergeant Polanco, who died of COVID, he was an officer at San Quentin, would have been a great witness for Tommy at a parole hearing. They would speak together how they would help their communities when Tommy was able to come home. So I fully support that. I'd like you to all please consider long-term determinate sentences while working on the penal code changes. And remember that ones with longer-term determinate sentences put into programming work as well as life. Thank you for your work and your time here. It's appreciated.
Thank you very much for your comment. I just have an update that I got a text from staff that, in fact, we are in touch with inmate family councils. So although they haven't been witnesses before the hearing yet, but staff has reached out and we are in touch. So just to give a brief update. Omega. Omgia. I'm sure I spelled, now it's not Omega, it's Omgia or something else. Can you please tell me how to pronounce your name? And you're on mute. It's my dyslexia. You're still on mute, we can't hear you. Omgia, can you hear us? I'll give you a couple more seconds and then we'll come back to you if you can't unmute yourself.
Hello, can you guys hear me?
We can hear you now. Sorry, can you tell me how to pronounce your name? I apologize for misspeaking before.
No problem. My name is actually Tyrant Kelly Sr., better known as Omega Chucky. I'm representing the founder of Trans of Anarchy Incorporated, as well as coming on behalf of Curb. And I know time and time again, and you keep saying it over and over again, that y'all not really focused on the LWOP and things like that. And I totally understand that, because that needs a 2/3 of a vote. But we just need to see if you guys can give us a real on that, because we need to be focused on the individuals that are in there that we need to get out. And I know you keep saying you're not focused on trying to get them out. And I'm a family member and also a formerly incarcerated survivor of this system and need people out as well. So the penal code is deep in need of revision. The California legislature has the ability to roll back LWOP sentencing in multiple ways that would have an important and lasting impact. And a big step would be abolishing USLE of the felony murdering system by repealing the PC Penal Code 190.2 subsections B, C, and D. This importantly impacts, as y'all know, Black, brown, and young people are sentenced to die in prison. And during COVID times, people are dying and dying and dying and dying. Don't need no additional way. So just speaking to get y'all to let people out of the system. So thank y'all. I know y'all running on time, so I'm going to speak.
Thank you for your comments. I'll just say one thing, because you mentioned COVID, is that you haven't heard a lot about COVID during these hearings. That's been intentional on our part, in that we don't, of course, are not ignorant to the fact that there's a crisis going on in the prison system with regard to COVID, and many of the people on this call, including myself and Senator Skinner, are working on this issue outside of this committee. But the committee, we are trying to focus on longer term systemic reforms. And it's not that we don't realize that it is a literally life or death situation going on in the prison system right now. But I thought that I should just clarify that.
I know earlier, Michael, that a lady, and I don't know if y'all answered it earlier, maybe I missed it when it was spoke on, as far as a way of opening it up with getting it involved with people who are in school or in universities who aren't allowed to research or get information or create transitional or rehabilitation centers because of the limitations on this area of studies and things like that. How do we get people to be able to study this population that's considered a vulnerable population in the studies, but then is considered a dangerous population to the public, of which you're talking about public safety. So how do we do that?
Well, I think that you also probably, if you're, for regular watchers, trying to get the data to try to really understand in a deep way the evidence of how the system works. And it's a huge ecosystem that begins, from arrest all the way through enhancements and parole and reentry, is really part of our mission. It's a giant undertaking, and we are trying to take bite-sized pieces in some sort of rational manner. But at the heart of it, I think, again, comes up every time, is gathering the data to try to make this a truly, I hate the term evidence-based, but truly evidence-based endeavor. Emily Rush.
Can you hear me?
I can, thank you.
Okay, wonderful. I have a question and some comments regarding the parole session you had. Have you guys ever done an audit? Because she said the 115s, the minor write-ups aren't affected. How many people that actually have paroled have those minor offenses? Because I just want to make sure that that was accurate. Regarding long-term sentences, also, have you thought about having a pilot to really dissect some individuals that are in prison right now with these long-term? I have a loved one that is in for 86 years for multiple counts of carjacking, robbery, and receiving stolen property with a firearm enhancement, but no injury. And he's not eligible for parole until 2032. He's been in dog programs, things like that. So just piloting and dissecting people's cases and trending what classes and programs that they are doing to better themselves to see if they're eligible earlier than the date set. I had one more thing. I apologize. Oh, is there any updates on commutations and tracking that? I have a loved one that had an interview with Governor Brown prior to him leaving. He did the reapplication, and it's been 2 years from Governor Newsom, and really there is no denial, approval, or any type of tracking regarding that.
So you touched on a couple of things. First of all, I'll just start with the dog programs because near and dear to my heart. You heard my pooch he's from the Lancaster Paws for Life program earlier, but more seriously, I think the theme of today was, how can we find ways for second looks? And, even Jennifer Schaefer brought up the idea that people are serving 100-year determinate sentences and have no chance to go before parole, and that really makes little sense. So I think that we're trying to figure some way around that. Now, a lot of initiatives and a lot of those laws are protected by initiatives, so there's difficulty there. And what was the last thing you said? I'm sorry, I was going to say something else.
Can you hear me?
Yes.
Okay, it was about commutation and tracking
the
application process.
Yes.
But there was one more thing that I forgot, and I apologize.
Okay, quickly go, and then I'll go.
Okay. It's about programming. He went from a Lancaster actually to a level 1. And now he's looking at a transfer because the programming isn't beneficial. And the counselors there are not equipped because it's a fire camp. So that's really where they are. They don't deal with the long-term offenders.
Yeah.
So we're going to be spending more money to transfer because programs are not consistent.
So is he in Paws for Life at Lancaster?
Yes, he was.
All right.
And he's now at Sierra's dog program as well.
All right. Well, again, thank you thank him for our pup. But the clemency process, I agree with you. Listen, it's a good process that I think that the governor and presidents should have an opportunity to find cases and exercise grace and recognize it. But it's not a good legal process. There's no transparency whatsoever. And it's like you're saying, you have no idea. It's a black box. So I wouldn't want to take away that power, but I really don't think it's a good long-term solution for some of the systemic problems that we are talking about. With that said, Governor Newsom announced, I think, 44 clemency grants yesterday. So I applaud that, of course. I just don't think it's the type of systemic reform that's needed. So anyway, thank you. Adam, are you next in line?
Hi, can you hear me?
Yes, Adam. And can you pronounce your last name for me?
No, it's Adamu. My name is Adamu Chan.
Adamu Chan. Excuse me for mispronouncing it.
Okay. I was released from San Quentin about 3 weeks ago.
Oh, wow. Congratulations.
Thank you. Through 1170D.
Oh, double congratulations.
Yes. And I had a 23-year sentence, and I was rounding out like the 12th year of my sentence when I was informed that I was going to be released. I guess I'm calling in today because I wanted to highlight the fact that at the sentencing phase of my trial, the same DA that requested me to be resentenced and released in this case was asking at that time for 85 years. And then at the beginning part of when I was being charged, that same DA offered a 3-year plea deal. So I say this just to illustrate the fact that there is this huge kind of discrepancy.
I got to interrupt you because I got to find out a little bit more about your case. So, okay. So you were in San Quentin for 12 years.
Right.
You got 1170D from Secretary Diaz?
No, from the DA in my county.
Oh, which
I was
county?
recommended by the DA
Which
in my
county?
Alameda County.
Okay, Alameda County. So did you work with Hillary Blount? Was she helpful for you?
No, I didn't.
Okay, well, regardless. Okay, so you got out through your DA, which is terrific, and congratulations.
Right.
And the DA, just to clarify again, for your original charge, the DA offered you a plea deal of 3 years.
Right. I went to
which
trial.
you went to trial, you were convicted, and then they asked for 85 years.
Right.
And then 12 years later, when the DA comes back and says, let's give him a new sentence, and they kind of stipulate to that in front of the judge.
Exactly.
And did that DA say anything to you, or is there any, I mean, it seems this all over the map, or can you just give us a little picture of what did the judge say? Can you just give us a little picture about like what might have been going on in their thinking, especially in the release process?
I think that when the district attorney reviewed, you know, some of my insights and, you know, the program that I had been involved in, and a lot of the things that I have been involved in while incarcerated, the DA believed that I should be out, and that I was no longer a danger to society and my community, and that I was an asset to that same community. And so, yeah, I mean, I just point this out to illustrate kind of not the arbitrary nature of like how sentencing works, but that like maybe, for lack of a better word, it can be fluid. And so that like 1170D is a mechanism by which people can be evaluated when maybe they're years out from a parole board date or even a parole date, or you know, they're just serving time when they, you know, could be up for an evaluation and be deemed you know, fit to re-enter society. And so I think that's a huge like gaping hole, especially during a time when we should be thinking about like how to make the system kind of smaller, right? And be releasing people when people are dying behind bars, and when we're spending exorbitant amounts of money to continue to incarcerate people.
And again, I'm going to take a little bit more time. How was your experience with the COVID problem in San Quentin?
Yeah, it was tragic. I didn't actually contract it, but a lot of people that I care about and that I was in community with at San Quentin contracted the virus and also passed away. And so when I speak about 1170D, I'm also speaking about those people. And I'm hoping that they can get consideration as well, because I'm not more deserving than anybody else.
Well, don't sell yourself short, because I don't necessarily believe that. I know that there's a lot of luck involved in everything, good luck and bad luck, but you also there's not a lot of people who've gotten 1170D, and it's usually a lot of hard work with not a lot of incentive to do that. So I wouldn't sell yourself short. I'm not saying that other people don't deserve it, but.
That's true. And I also recognize the ways in which I've been privileged to have community support and advocacy around me, and, you know, where other people haven't had that.
I presume you know Adnan?
Yes.
Okay. Well, reach out for help. Getting back into society after serving a fairly long time behind bars is not an easy thing. I tell all my clients it's a marathon, not a sprint. My office also has excellent resources in Alameda County if you're still there. So you can reach out to me through the 3 Strikes Project at Stanford if I can be any assistance for you. But good luck to you.
Thank you. I'll be in touch.
All right. Mrs. Espitia, gosh, I'm the worst. Can you pronounce your name for me, please?
Espitia.
Espitia, thank you.
Yes. I'm just calling in regards to my husband's incarcerated. He was sentenced at 15 years old to 27 years to life.
Oh my gosh.
He is currently on his 26th year. And I just think a 15-year-old, 16-year-old, 17-year-old should not be thrown into prison. Obviously something's wrong and they're doing the wrong things. To throw them into the world's worst place, prison, at 17 years old is never going to help them. They're never going to get the resources, the help that they need. And he went in 96. And back in that time, going in as a juvenile lifer, they don't give you a priority of getting into school. They don't encourage you to get into school. They tell you, you know, you got time, go sit down. And then those same people want to say, well, why weren't you programming? What took you so long to program when you go to board, you know? And you can't say, well, because back in 96, they didn't care about me, because then you're downplaying it and you're minimizing it.
You're criticizing.
You don't have insight.
Yeah.
Yes.
Yeah.
Where
is he now?
And I think he's at SADF. And he will be going up to board in 3 weeks.
Oh, wow.
And I think that letting them understand what parole means when they get in there, helping them realize that they have the chance to parole and what parole is, what it means, and what they need to do in the beginning, even if they're not listening, needs to be done. He went to parole in 2015, and he went in there scared. He went in there feeling like he was going back to court, and anything he said can and will be held against him, rather than I'm going in here to show them who I really am today.
I don't mean to interrupt, but for somebody to not be scared before the parole board, I think would be an unreasonable approach.
Yeah, but just helping them distinguish the fact between parole board and trial or courts and judges is what they need to, you know.
No, I know it's. I mean, as somebody who sat, I mean, I've never obviously been there with my life on the line, but I've sat next to people with people's lives on the line, people who are eminently prepared, that I've personally prepared, who've worked so hard for decades. They walk in and the first thing they do is they break down bawling because it's such an intense experience. I wish him the best of luck, obviously. And, you know, I think you heard today that we think that it's a problematic system. That is something that we hope to try to address. I know that won't be in time for 3 weeks, but I hope you have good news.
Thank you.
All right, Miss Jane Current.
I'm sorry. Hello.
Hello.
Thank you very much. I've been with you all day.
Thank you for your patience.
I'm very interested in all this. I am a longtime volunteer at San Quentin. I've also done a few years volunteering up at Solano. And I have met many, many men, such as I know Adnan and Adamu, and I have met so many men. They are not exceptions. The kind of work that people do is just humbling. I'm always amazed at the positivity and the hopefulness, considering how dreadful the circumstances are being imprisoned. And it's just my firm belief that, as you well know, and as you all talked about today, that these people are no threat to public safety, and it's quite the opposite. You've heard from Sam, from Shanae, more recently Adnan, the kind of work they're doing in the community. They're needed out here. And so I know you've got a narrow range that you're supposed to be trying to deal with the reforms that can get through the Assembly and the Senate on the 2/3. But I just urge this committee to really look at more sweeping changes, particularly enhancements. I can't think of almost every man I meet there. I hear the stories, and I hear the gun enhancements, the gang enhancements, the gun enhancements and the gang enhancements, the lack of the exception for the 10 to 20, these extreme sentences that are just outrageous. So when you're looking at this penal code, I would suggest that the ending of these enhancements somehow that they can be eliminated in the actual process of the 1170, with a presumption that enhancement time is going to be removed when the laws that repeal them or make them discretionary are there. So whether or not these are retroactive laws, I really would like for you to look at the enhancement question when you're looking at the revision of 1170. And again, all the issues you've discussed today, I certainly appreciate the attention. And as Dean Richardson said, you've only got the mandate to tinker, and yet we all know that the systematic failures are huge. So thank you for listening.
A couple things. First of all, I hope you tune in tomorrow where we'll be talking about enhancements, which is we're going to reflect on our hearing from last month, which we talk about enhancements. I guess I appreciate that you think our mandate is small and tinkering. Sometimes we feel like it's overwhelming. I will also say that the vast majority of people who are locked up in California are not subject to our laws that are within a simple majority vote of the legislature.
Good, I'm glad to hear
majority. Now, the ones that sometimes get the most attention, like LWOP and 3 strikes, those are protected by initiative. But the vast majority of people in the system who don't have a voice, sometimes because they aren't serving these sentences under these kind of famous and extreme laws, those are really within our target on top of the enhancements. With the exception that some of the most important enhancements are protected by initiative, and it's but thank you again, and thank you for your patience this whole time and being with us. Okay, the next person is a caller. Your telephone number 213-802-2670. If you could introduce yourself. You're on mute, though.
Yes, hello. Hi, good evening. My name is Mary Moreno. And first of all, I would like to thank you guys for this great opportunity. And I just want to say that you guys don't know how meaningful this is to, especially myself, because I had lost all hope of, the parole board. My husband is currently incarcerated. He served 20 years. He was recently denied in July, and it was for reasons that, I'm not being subjective, but do not make sense. He was in jail, awaiting trial for 3 years, was in Folsom State Prison, served 15 years at Folsom State Prison, a maximum security prison, very notorious for being, very violent. He was not offered any programming there because he is a lifer, and he was told upon arrival to just stay out of trouble and keep his nose clean. As for him, there was very little possibility of programming and, the possibility of coming home. When he went to board on July, he was told that he did not have enough clean time. The Board of Parole did not take into consideration that he didn't have that opportunity to program until he did go to a level 3 on his 16th year of incarceration, and in less than 2 years to a level 2 prison, which is where he currently is housed. It is until then that he got the opportunity to actually have significant programming and work on his rehabilitation. This rationale behind the Board of Parole hearing and their decisions is really I don't know how to put it into words, but it is not rational, and it really is unrealistic. The expectations they have are really unrealistic. And I believe, as Ms. Poole said earlier during one of your panels, they don't look at the person that's in front of you, in front of them. They look at a bunch of papers, and they are unable to really determine who the person has become. they look more on the past and the crime, and they look at the behavior in prison, which oftentimes is also an issue because they have to face so many challenges in there, and just to keep their head above water is a challenge. So I really appreciate that you guys have come together collectively to work on this process and make some significant changes, because a lot of people, behind those walls are really depending on that. My husband contracted COVID in August. He was denied treatment and the medicine that was prescribed to him. And I could tell you right now that he's only alive because of the grace of God, not because he received any adequate medical health care in there. So I really, really appreciate this. And I really, really would like for you guys to consider, these challenges and continue to push through this and not let this issue just disappear, because it has happened many times where, something like this happens and then, the days go by and it disappears and just nobody talks about it anymore. So I really appreciate you, and I'm sorry if I'm rambling, I'm very nervous, but I really appreciate that you consider that this is only one story, our story, but there's thousands of stories, similar to ours, and our loved ones do not pose a threat to society, and they really are ready to come home and make changes. Thank you.
Thank you for your comment. Can you see your screen, or are you just on your phone? I have a quick question for you.
No, I'm just on my phone. I actually got disconnected several times, so I had to call back in.
Okay. Well, thank you. And I was going to say the parole standard is, a real, I hope that you appreciate that we appreciate the parole. I was going to say my war stories for tomorrow, but, I have a client where they said, you're at risk of running a stop sign or a red light, and that could constitute a danger to society. So like, we get it, or I get it. It's easy to find, sometimes it's easier to find the problems, the harder part is sometimes to try to find the solutions. It's really what we're dedicated to. We're obviously spending a lot of time on it. There are a lot of people who are really working hard on this, not just the members of the committee, but there's a whole staff. If we thought that we weren't going to have an impact, we wouldn't be doing it. I wouldn't be doing it. So we're very hopeful. Obviously, this is our first year in existence, so we'll see next year about what we can, get done. But thank you for your comment and for staying with us. Elisa, I think you're next.
Hello, can you hear me?
I can.
Hi, I'm Dr. Elisa Bieria, a faculty member at UC Riverside. Thank you so much for this hearing. There's a presumption that the purpose of parole hearings is to determine if someone is prepared to be released. However, when you look at the incredibly low parole grant rate, and specifically at BPH transcripts, and the reasons why many people are denied parole, it's clear that the purpose of parole hearings is for board members to find reasons for why people should not be released. In my review of transcripts, I've seen people denied parole because they are transgender, and the board conflated being transgender with being duplicitous, because they're a survivor of domestic violence and they didn't attend a DV group during their time of incarceration, or because they're navigating a mental illness. Now, none of those are crimes, yet when people are denied parole for these reasons, they become de facto crimes, because the BPH is punishing people for being transgender, not attending a DV group, or having a mental illness with further incarceration. So the BPH is creating perpetual incarceration for the most vulnerable people. And further, and I think you all covered this earlier, the board tends to squeeze justifications for denying parole into the ever elastic category of, quote, lacking insight, which is a category that's vague, very questionable in terms of social science, and extremely vulnerable to multiple forms of bias. This is deeply unjust, and it's unconscionable during a pandemic, which we just heard about, where extending a prison sentence could mean the possibility of death, which of course is a grave public safety and public health failure. I believe that we need to switch to a system that has presumptive parole with administrative review, which includes outside and independent oversight. Continued incarceration should not be the default. Parole should be the default. It must be presumed and it must be the norm. This is the only way, I think, to end the perpetual incarceration facilitated by a parole hearing process that's fundamentally biased. It's contributing to a public health crisis, and it's obviously unjust. Thank you so much.
Thank you for your comment. I'm very curious to see those parole transcripts that you alluded to, and I would love it if you would email them to me at mromano@stanford.edu. We're trying to collect some of these because I really would love to see those few.
I'd be happy to.
My email again is mromano@stanford.edu.
I will definitely do that.
All right.
Absolutely.
Thank you. Last but not least, Elizabeth Frazier. Thank you for staying with us, and I'm very curious to hear what you have to say.
Well, thank you for.
Somebody else is joining. You're not last but not least. Oh, well.
Oh, okay. Well, I was going to say
I'm still curious to what you have to say.
Thank you. I listened to the whole hearing and then had to leave for a meeting at 5 o'clock. So I was really glad to see after all that time that there was still an opportunity to speak now. So I want to start by saying that having listened to the whole hearing today, and in particular the final panel, the only conclusion that I think can be drawn is that prisons cause trauma, that they're not places for healing, and that they don't promote safety. I know you're looking for specific penal code revision recommendations, so I'm going to make two, but I just felt like I need to say that they feel really inadequate in light of that conclusion because they don't address the entirety of the issue that has been presented, not just today, but in all of the hearings that have happened so far, and I've been here for all of them. Okay, my first recommendation has to do with 1170D. I think you've heard several recommendations on this today. I want to talk about 1170D in terms of enhancements and to recommend an amendment to create a process and presumption in favor of enhancement time being removed when laws pass that repeal or make discretionary certain enhancements. We've seen so many important laws passed in recent years to repeal or make discretionary gun enhancements, drug enhancements, prior enhancements, nickel priors, but they're never retroactive. I really strongly believe that groups like public defenders, CDCR, district attorneys could work either independently or collaboratively to create lists of people who have been sentenced with those enhancements by county and come up with a process to remove those enhancements en masse. I know 1170D specifically talks about the importance of the statute to ensure the interest of justice. And to me, the interest of justice does not mean people serving decades and decades and decades of enhancement time when those enhancements have been repealed. The second has to do with parole, and specifically elderly parole. I know that I've heard many times that this committee is interested in data and evidence, and the data and evidence is clear that older incarcerated individuals have reduced recidivism, they have reduced arrest rates, they have some of the highest parole success rates. But despite this, the parole suitability rate for older incarcerated folks in California is almost 10 points below the overall suitability rate. We also have 1 in 4 people who are incarcerated in the state of California right now are over the age of 50. So we had a great bill this year, AB 3234, that amended and expanded the eligibility for elder parole. So people 50 years of age or older and who have served 20 years are eligible, but it included a ton of carve-outs, and they're carve-outs that weren't in the original court-ordered elder parole program that was ordered by the Plata courts. And as a result, even in the bill analysis, it said that they only expected parole opportunities to be extended to 240 individuals as a result of this huge eligibility expansion in terms of age and time served. And so I really, really hope that this committee will recommend re-examining that and not having carve-outs for elderly parole hearings. I believe that folks that are elderly, especially in this time of coronavirus, need to be able to have a mechanism to go before the parole board. And as part of that as well, well to not be denied for 15 years. You know, to be denied parole eligibility for 15 years at the age of 65 is essentially a death sentence. So to have shorter amounts. And so this is, you probably know this, but this would require amending sections 3041, 3046, and 3055 in the Penal Code.
Like I said earlier, we regretted that we weren't able to get to medical parole, elder parole, and some of the other pieces of the parole process. A lot of the carve-outs, and I don't know what the specific legislative history was of the bill last year, are because there are so many laws that are protected by initiative and would require a 2/3 vote. So you carve out those cases, 3 strike cases or whatnot. Senator Skinner.
That wasn't the reason. It's a, I don't know if we want to get into this here, but it was supposed to be part of the budget trailer bill. There was not appropriate discussion that occurred in advance in the Assembly. The Assembly Public Safety Budget Committee did not even hold a hearing. Had they held a hearing, it might have been embraced as part of the negotiated budget deal, but because that didn't happen, it kind of fell apart in the Assembly, and then it became just a single bill instead of part of the budget trailer bill. And in order to get the votes that were that needed to get it passed, various carve-outs were made. But if you look at the original budget trailer bill, none of those carve-outs were there. So that's how it happened. But I would say, though, even without that expansion, what we have unfortunately experienced, because there is the ability for CDCR or any particular, there's much ability for elderly and medical parole. It was not happening regardless. So, we need to revisit how that's done, because regardless of carve-outs or anything else, we have not had at least from my point of view as being a long-term legislator who has opened the opportunity for these categories to be paroled, it has never met what my perception was the legislative intent.
So there you have it. That's the longer story. I think one of the broader missions of this committee, though, is to give these ideas more airing than a typical committee could have, and hopefully inform the legislatures when they come back in session, legislators and the committees, and be of service. And we spent the whole year doing this, and I hope our report will be helpful in that regard. All right, now we are truly up to the last person. Joseph, thank you for staying with us. I'm going to ask you also to pronounce your last name rather than me mangled it. So very curious what you have to say.
Okay, thank you. My hand was raised before it lowered itself, and thank you for accepting me once I noticed. Maislish is my last name. I'm a marriage and family therapist, and on the steering committee of LA Regional Reentry Partnership, although I'm not representing them officially in my remarks today. I'm also just so thankful to hear you talking about things that I was thinking of and things that I wasn't thinking of 52 years ago when I did 2.5 years on a 3-year federal sentence in institutions of all security levels. Last month, I brought up this issue of when is it a matter of time or is it a matter of personal development? When is a person suited for release? And as long as it's a choice, actually, because if it's a matter of time, people will naturally keep their eyes on the clock, or at least one eye on the clock. And if it's a matter of personal development, they will tend much more to think about themselves and their development. So I know this is a background point for you, but it can affect these various decisions and recommendations that you make. And I believe we have to emphasize the personal development part. How do we measure it? I'm going to send you folks a link to an article called Empathy Works. Obedience Does Not, by a emeritus criminology professor that I know. And how do you measure it? That's the problem. I'm concerned about the emphasis on violence. Let's remember that some of the most damaging acts, criminal acts and non-criminal acts, are nonviolent. They generate many, many many violent acts. For example, mortgage fraud.
Joseph, we lost you. All right, Joseph, I'm sorry we lost you and your time is kind of up. We saw one last person and this is going to be it. I'm going to close it after this. Lisa.
Hello? Can you hear
Hello?
me? Yes.
We can.
Okay. I'm sorry. I raised my hand several times. I don't know why I wasn't in the queue, but
Well,
and anyway, thank
here's
you
your time.
for taking me. And these are the code changes that I changed. And and on a basic level, 1170 saying that the purpose of incarceration is punishment. That I think, just initially substantially, just that kind of out the gate needs to be changed. The purpose of incarceration should not be punishment. It should be public safety. And with that focus, because what we're doing is just basically creating a system that creates, as you said, more trauma and just more when we should be, what we want is safety for our public. But I want to go through the code changes really quickly because I know I don't have much time. Talking about embezzlement, so the code 503 to 515. I know a person who sold textbooks that were thrown away and was charged with embezzlement. This was someone who had no priors, nothing, worked for a college, and was basically like racked through the coals. It was completely ridiculous. These are the types of things that kind of need to be changed within the code because they can be used, against people who are doing things that they don't even realize are crimes. Number 203, mayhem. If you slit a nose, ear, or lip, women, this, I believe, this code in mayhem has a gender bias against women because when women fight, they have a tendency to kind of claw and to fight in a way that, they have long nails, they could slit a lip, someone could bite their own lip. These types of things create these ridiculous overcharges that DAs use against people who may have other charges that are violent, but they tack that on as a kind of an enhancement in their charges. People get sandbagged with all these charges, and that's the reason why they'll, instead of fighting, they get scared and they just plea, especially when they're put in jail and then they see a bunch of other people who have fought their cases and lost and got worse sentencing than people who pled. I know a woman who drove her sister to a place, fought her case. Her sister was a drug dealer. She wasn't really sure if her sister had drugs or whatever, sending her that, but her sister got a 2-year plea bargain. She got 7 years. This is someone with no priors, no history, no nothing.
So Lisa, I'm gonna cut you off because I hear what you're saying.
I just want to say one more thing that I think is really important.
Sure.
DAs need to be, there needs to be much more accountability with DAs. I have seen, and I'm kind of piggybacking on what this other guy said previous when he was talking about exculpable evidence. And I know that you said that this is not for that, but it needs to be a little bit within your thought process. The witness tampering that DAs do when witnesses come forward and then they say, oh, we're going to charge you with something if you don't do X, Y, and Z. And that happens a lot. This needs to be within your realm of thinking.
I'm sorry, I'm going to cut you off. I do appreciate this. I truly do. I mean, I'm a criminal defense lawyer. I've represented these people. I used to work at the Innocence Project. I'm fully aware of all sorts of problems that go on with exculpatory evidence being hidden, unfair practices by DAs, by police. And I think that it's something that this committee does care about and will eventually address. We decided this year as a group to focus on sentencing and sentence lengths across the board, but this is a standing committee. We will have new projects next year. And so we've decided to focus on sentencing, which is not unrelated to what you're saying about taking plea deals that are maybe not necessarily appropriate, because the sentences can be so long, and enhancements that we've talked about over and over again. So with that, I'm going to pause our proceedings until tomorrow morning. There's still 50 of you still with us. Thank you for your time and your patience and your input. It really does mean a lot to us, especially the specific recommendations. We'll be back online tomorrow morning at 9 a.m. for deliberations about some of the stuff that we talked about today and proposals moving forward. So for those of you who are tracking us closely, I encourage you all to tune in. For everybody else, have a good evening. I will see you tomorrow morning.
Thank you.
Goodbye.